Well, we're going to start the last roundtable discussion that will end the workshop, and then we'll finish with some concluding remarks.
Yes.
By me, Julius, Laura, do you want some? No. Okay. No. The youth of today is not the youth of all days. Okay. Tomáš.
So thank you very much for the invitation to this group. We have heard some great presentations, fascinating and open discussions. We value that. It's very different what I'm used to at various international fora. This roundtable should serve to continue some of those discussions and perhaps expand to topics and technologies that have been covered in the past few days. And the concluding sessions of workshops and conferences usually serve as the way ahead. Can also tend to be more freestyle, so I'll just steer the debate with a lighter touch. I think we can take as much time as Guido gives us. And I believe that the role of academia is identifying questions that are posed by practitioners and decision makers, providing answers before the questions are posed. I'm a lawyer by education. For the past 5 years, I've been working for a government agency in a role where we try to develop policy and law, which means our work is driven by political priorities. We have to make compromises, so work under time pressure, so it's more of dirty work than the work I was used to in the academia. I try to put that schedule on the side. I could talk about the lack of regulatory impact assessment in the EU or about convoluted processes in cyber groups, but primarily I hear their opinions about the topics based on the government level. So together with Guido, we have identified several key areas that reach international law, technology, and human rights, and conflicts and counterterrorism. So these key areas are critical infrastructure and security. Second one is emerging technologies. Third one, attribution and accountability. And if we have time, we can also cover encryption and data privacy. We'll give each of them 15 to 20 minutes. So we start with the first one, critical infrastructure and security. We identified several interesting topics there. Cloud security, submarine cables, ICE, SCADA, energy sector security. So I would like to ask a few questions on this. The legal and operational challenges of protecting critical infrastructure during armed conflicts and counterterrorism operations. Perhaps I myself would like to add also cyber and hybrid operations generally. Town manual doesn't have much to say about critical infrastructure such, except that it's not that well defined term in international law. Nationally, there's a bit more. So at EU level, IS2 directive, CR directive, which was supposed to be implemented by October this year. 23 out of 27 EU states did manage in time, trying to catch up. With regard to cloud security, there are several twists to the debate. Whether it's a good idea to have national data abroad, government systems, population and land registries. The question of data investment has been discussed in this context. So we heard about this framework help from Microsoft, AWS, and other companies to migrate government data to the cloud on 24th of February 2022. So clouds would be a good idea, but on the other hand, what about control systems of electricity grids? Companies are trying to cut costs, concentrating these services for several countries in a single location. What if there's a problem? State on whose territory the control center is located decide to protect its national interest and shuts down the grid or does something that other states might not like. So do you have any ideas on this in regard to international law, whether there are positive obligations that come into play? I'd be very glad to hear.
So I think that an interesting question. I think that we've touched a little bit about that before with one of Marco's example about data taking to the state, and then the question of the cloud, and then there is a question about what happens when the state gets cyber control over a computer extraterritorially. What is the level of control that we can even talk about that will invoke certain aspects of human rights, and what would be the obligation of the states with regard to those human rights, positive, negative, and one could imagine a scenario where a state is hacking to gain control over a cloud or a specific computer and find some troubling information in the computer, for example, child pornography. Does the state have an obligation to act on that information? Does it have any obligation towards the children that are being abused? Does it have any obligation towards the owner of that computer, for example, if it's not child pornography, it's personal naked photos of the owner of the computer? Do they have some responsibility to protect that information, to prevent it from the people at the office who are obtaining the control, to watch it or to distribute it, etc.? So what happens when a state agents gains control over a computer or cloud extraterritorially with regard to human rights application? As an open question, or then a state.
But it's kind of a different question from his focus on critical infrastructure.
Yeah, it's a little bit, but the cloud is critical infrastructure. Unless you disagree that the cloud would be considered as a critical infrastructure.
Well, critical infrastructure might be using cloud control very so yeah, they might be linked in this particular way. And of course, so there are tendencies in the EU to regulate this, issue certifications and discussions whether to limit certain services from being provided from countries outside the EU or outside states that have a similar or adequate level of protection compared to the EU. These are actually the debates that are going on right now. So that's why I asked their opinion on this. Whether you think international law might have any answers for this. You can limit certain data from being stored abroad or outside the EU. Yeah, there are international law.
Again, that's a third issue.
Okay.
like data localization. If that's what you're talking, like that's a separate issue from attacks on critical infrastructure. No, you need to pick what we're gonna do. Like, I mean, one issue is Russia attacks hospitals or Russia attacks water supply. Is that one scenario? And does that violate human rights law? Does that violate some other parts of international law, right? I mean, this has been discussed quite a bit. Then there's the question of when does the state have a duty to protect, which was Ida's question. And it has a duty to protect its own people, but does it ever have a duty to protect other people? And then maybe as part of that duty to protect, there's this whole question of data localization. Is that kind of rule appropriate to force companies to keep their stuff on your territory? So what do you want to do? What do you want to do?
I'm just offering questions.
I think they're all intertwined, aren't they? The roundtable topic is law and technology. It's technology and law. So
It's like a snake eating its tail.
But the game Snake is part of technology.
Sorry?
The game Snake
Oh, okay.
on your phone.
Okay.
So perhaps the duty to protect our own people.
From a human rights perspective,
Yes, yes.
I would think that's pretty straightforward, no?
like the right to security.
Well, I mean, the right to life, the right to health, the right to water, the right to food, all those rights.
To what extent do we think, isn't it going back to the debate whether like collective, like public unidentified individuals, can we think about the interest in this regard as something that relates to this open question, extremely controversial? Because then it makes the entire counterterrorism debate to a debate about balancing human rights, which is not the way that we think we should counter like state measures.
I'm not sure how. So already,
Right. So
in the
the state
mechanics,
says, right? Yeah, like at least we have domestic constitutional law debates around this issue. About whether a state that says, when we impose security measures, what we do is
protecting the right
to life, and therefore it's all about balancing, which makes it much easier from the state perspective to pursue these measures with less scrutiny. And if instead you treat it as the state has a duty and obligation, generally like to, and you look at it as in the realm of state interest, it makes it easier to protect abusing of rights by states because it doesn't look like everything that it does is in the realm of protecting human rights. So there's a danger that collapsing everything to balancing of human rights will actually...
Okay, sure, but that's not the case for attacks on critical infrastructure, which killed people.
Like the whole force protection versus enemy civilians debate.
Okay.
If you make it a discussion of human rights, right, changes the ability.
Sorry, so imagine there's a following scenario. There's a cyber attack on Czech, on the water supply in the city of Prague. And for years, the Czech government was completely negligent and provided zero incentive to and zero help to whatever the company is that manages the water supply to fix their vulnerabilities. And the attack causes, I don't know how much harm in Prague. Could you file a case in the European Court of Human Rights arguing that the Czech Republic failed to secure the right to life or whatever the right to prohibition of inhumation? Sure. I mean, I think that's fairly clear, but it has to be a pretty dramatic case of negligence, basically. Like, I mean, it has to be something like bad. I would think, like, no state would, I think, disagree with this proposition. And especially if you include socioeconomic rights, you have a positive duty to protect all these rights. The question is, what do you do about it?
Although that's socioeconomic rights according to the available resources, so the state can answer back that look, we wanted to do to protect the people of the water flood, but we didn't do enough.
But actually, yes and no. So available resources when it comes to socioeconomic rights is about the duty to fulfill. How many hospitals you're going to build, how many schools you're going to build. This is the duty to protect from third parties. So, and it's a different question. It's like you need to secure hospitals that you have, you need to secure water supply that you have, you need to secure your food supply. I mean, again, I don't see a conceptual issue.
So if a state did not have like a mass surveillance program where it hacks the phones of everyone, and a terrorist that could have been found using these measures succeed in committing a terror attack, does the state violate the right to life?
No.
Right. So this is not the way that we think about it usually, but can we?
But it is, right?
Isn't it like possible to suggest, right? They have a positive side to the right to life. They need to actively protect them. If they're not doing these massive operations,
it is how we think about it. In the McCann case, the first decided case on the right to life, the court is dealing with the use of lethal force by state agents. The court expressly says the UK has the right to protect the right to life of all people in Gibraltar, which is endangered by allowing these terrorists whom it knew they had thought they had a bomb to enter. It also has a duty to respect the right to life of the terrorists, right? And so, yes, you have to take into account to protect public safety when you use lethal force. It is a balancing exercise in the end.
But there are two questions that come out of it. One, we're jumping to the big guns of the right to life. There are several other rights that are relevant and are not as critical to, I mean, right to life is the big guns. I have to say, I have to do everything I can in order to protect lives, etc. But, you know, freedom of movement, if the critical infrastructure is an attack that makes the train slower, I mean, it affects, it has a damage, it has a huge economical damage over the state, but it won't kill anyone unless, you know, a doctor that is late for operation. But generally it's, so what is the obligation of the state to prepare itself from any type of attack on its critical infrastructure, not only the ones that will cause deaths, otherwise it would be negligent on the side of the state. And what is the meaning of such an attack against critical infrastructure that doesn't cause deaths, but causes damage, general damage? So not jumping to the big guns.
So the duty to protect, I mean, the court applies the right to privacy in the simplest case. So just 2 days ago, they decided a case against, I think, Romania, where a woman was in a relationship with some idiot guy. She sent him sexually explicit images of herself, and he then used this as revenge porn. Like, so he put it up on various websites, you know, the classical type of thing. The Romanian prosecutorial authorities basically said, let's just go away, woman. Yeah, the European Court finds a violation of Article 8 saying you fail to protect the woman. So I like, yeah, it's contextual, like that duty applies to every human right. Yeah, the question is, what are you supposed to do? Like, it's a very fact-intensive question. Like, don't tell a woman 3 years later to go away is like the answer in that particular case.
Yeah. But again, I think there's a difference between civil political rights right now, what you mentioned now, and the economic rights, where the state should be expected to take measures. In principle, every state is expected to take measures, but how plausible is it to expect the state will take these measures, and how easy it is for the state to take these kind of measures to protect the socio-economic rights, which are tied to the socio-economic agenda, also to resources again. So maybe there's a difference here in the approach between the two groups of rights.
Maybe to add another twist to the question, there's also the argument of freedom to conduct a business from companies that provide cloud services. Let's say some states trying to limit where they actually host that particular cloud. So is that like a legitimate human rights argument from their perspective? Like telling the governments, yeah, we should not really limit our business in this way. By telling us to.
Is the freedom to conduct a business an EU law thing?
And not only, it's HR as well articulate.
Oh, I see.
You have a couple of cases where this is derived for, but it's mostly charged. But I think it's a very weak right in the end. Like it's always subjected to proportionality, and if national security comes in play, freedom to conduct business goes. The only interesting thing that has happened in the past couple of years, and that's what is stressed by Luxembourg, is companies trying this when prohibiting people religious signs. And this is where the freedom No, it has been deteriorating there as well. So about 7, 8 years ago, it was a strong rise. So companies could say we're ideologically neutral and we don't want to any jobs and stuff like that.
The uniform of employees,
Yeah.
that type of thing. Okay.
And today the EU says, okay, but if you prohibit people to wear religious clothing, your reason for that has to be stronger than their belief in God, which is that balance. So it's a super right.
Good to hear.
I mean, the equivalent European Human Rights Court case of that is called OEDA. It's about a couple of different cases: a British Airways flight attendant and what she wears, a nurse and what she wears, and so on. The court says it's justified to restrict clothing, like wearing a cross in some respects. In other cases, it's not justified.
Well, the funny thing is, it's 4 joint cases and 2 go one way and 2 go the other way. So they don't even know what Strasbourg thinks.
Yeah.
Was there any logic to that?
There was a logic. So, for example, a nurse, they told a hospital could prohibit a nurse wearing a necklace with a cross because the nurse could contaminate wounds. It could do that type of stuff. Mm-hmm. But you can't prohibit a flight attendant from wearing a cross because, it has nothing to do with.
So the problem was not the religious symbol, but the pendulum.
Basically, like any jewelry.
So yeah, unless there are more questions and answers on clouds and particular infrastructure, we might move on to.
So can I give a specific example that I think is useful? So that's ransomware attacks. If we're talking about protecting data and privacy rather than life, ransomware attacks against hospitals or medical institutions that have the most sensitive data of people. Right, so a hacker group hacks a psychotherapy company and obtains all the records of people going therapy. Yeah, and then says we're going to put that on the dark web unless you give us money. Does the state have a duty to protect? Yes. So it has to regulate how, what kind of mechanisms of protection a company of that type is supposed to employ to minimize, not eliminate, but minimize the chance of something like this happening.
Can it legislate a law forbidding the company to pay the ransom?
That's an interesting question. There's been this type of stuff in the the terrorism kind of stuff.
Actually, a company should not pay ransom when the attack is state is they forbidden. Because terrorism, terrorism reasons. Because you can't fund terrorism organizations, so you can't pay. You are prohibited to pay.
According to
terrorism support law,
it's a national choice.
Yeah.
That's a national choice. Each state.
I speak about Israel. Okay, of course. For example. Yeah. For example, in Israel, they are forbidden.
So now I'm the patient. My information got exposed because the company didn't pay. Can I file? Well, if I file a lawsuit saying that law has caused a violation of my right, anybody would take that claim seriously?
So no, we get rejected. There's a really sound reason for prohibiting payments, and you don't want to fund terrorists who kill people.
There's nothing you can do against the company.
You're suing someone who didn't cause the problem, right?
Also that.
There will be a breach of the chain of causation somewhere, unless they were negligent, super negligent with their case.
Also the concurrence of being the victim and being a culprit in some other case. Okay, so
have you have something?
About what you said previously. If, for example, according to the Intermittent Court of Human Rights in 2022, there was if, for example, a state and its territory, because of an activity is responsible, an activity that has that cause damages to the population of another state. According to the Intermittent Court of Human Rights, that state is responsible. but I think, I guess, it's a matter of environment. And it's
the advisor opinion on the right to life in the environment.
Yes. I think it's maybe it would be the same for matter of technology, maybe.
So that's the case where the court basically says if a company in state A pollutes and causes transboundary harm in state B, then the people in state B are under the jurisdiction of state A for the purposes of the American Convention. So that means under the American Convention, each state is basically expected to prevent transboundary environmental harm emanating from its territory, and you can very easily, by analogy, say that applies to cyber harms. So if there's a cyber harm emanating from your territory, you have to stop it. But that's the inter-American court's approach. It's not the approach of the European courts, right? Others haven't said that. Yeah. There's this whole issue of the Business and Human Rights Treaty and what is going to say about regulating extraterritorially. What business, your business is, what does NSO do abroad, yeah?
But that's not state, that's companies.
But the state has to regulate the businesses. So the treaty will basically impose a duty, as it's currently drafted, that, I don't know, the Netherlands has to regulate Royal Dutch Shell when they operate in Nigeria. So the treaty...
What happens if it's the Dutch military that does the...
That's easier.
Why is it easier?
Yeah,
so it's a negative duty rather than a positive duty issue. Yeah.
So I have maybe a broader question about law and technology in the context of our workshop, and it goes back somehow to Marco's piece, because one of the main questions about the piece was, is it about lies as a problem or about lies as means to violate human rights? I think that when it comes to technology, I wonder, what does it do to our discussion of IHL and human rights and in the relationship between the two? And I think that the example with the facial recognition is a good one, right? Because to some extent, it raises the question of to what extent intelligence gathering violates human rights regardless of technology. And we know that there are practices who are maybe much worse, right? That also relate to some of the examples in your line piece, right? And I wonder here whether the technology just allows us to rethink this issue, because it didn't seem to capture much attention before. So there's almost no scholarship on whether practices of intelligence gathering violate human rights during armed conflict when they do it. But when we think about facial recognition or surveillance, we do suddenly talk about it. So do you think that there is something unique about it? Or is it just something that was hidden and talked about and raised actually exactly the same issues, and we should look at it? And it goes back to something that like I wasn't convinced by the example of poisoning the tea. So clearly when we talk about extraterritorial application, yeah, sure. But it doesn't solve the problem of the relationship between the two regimes, right? We can say, sure, human rights, but they're replaced in action. And I think that there is a good reason to think that at some level of intensity, the whole idea of IHL, the ethos of minimizing suffering at the expense of many other things that in daily life we refer to as differently, does capture something, especially when it comes to issues such as privacy and so on. So,
could you explain that? Time?
Yeah. So, okay, when we design these programs, clearly we should take, we should address all of the human rights issues. But during an intense battle, right? Then the question, it goes back to what, and now I take the other position, like I'm closer to Ziv, but what I'm saying is it reasonable to expect, if we want to minimize suffering in warfare as the ultimate goal, to take into consideration in each operation this broad set of issues effectively in a way that will not significantly interfere with the some of the assumption that we need to have clear-cut rules that we can apply fast in order to minimize. So could it be a place where human rights actually replaced or received minimal action? But it can also be a statement. It's fine.
No, but I think it's even generally maybe even say that the question is, how does law change the reality on the ground, and how does it then affect the legal principles? If it's not really a qualitative change, the law doesn't, technology doesn't really make a difference in a way. And then you can just say, well, it's different, but yeah. On the other hand, it's that's been like because I'm in the law and technology, I'm doing like these foundational questions, and it's in many cases I have seen that people suddenly start talking about certain issues that were not discussed before, and then suddenly technology comes into play, and it becomes an issue, and it's not always justified to that it's an issue, but technology highlights something. Sometimes it's even that the fact that how technology is trained, that we have these algorithms and machine learning that need to use data, suddenly we gather these data and see things in the data that mirror to us how biased, whatever our practices are. So I think you're like, you're totally on to like a general issue in this law and technology. It doesn't answer your question, but it's a valid question.
I suppose the bottom line is some technological issues are transformative, others are not.
Yeah, but
AI, everybody agrees is really special.
But it's not just. Of course, AI is transformative, but not everywhere.
Sure. Yeah.
Like so, the cipher is it transformative in the question you're dealing with, not just because it's AI.
Yeah.
I think that is an important distinction, because not everything is like.
Sure.
No, I also think that there's some assumption, and it goes back to like taking the neighbors and as example, kind of you call it joint procedure.
I think it was that one.
The assumption that there is always the ability of not acting or not conducting some kind of action is totally makes sense in regular times. In like a heated battle, something will be attacked. And when it comes to these general issues of privacy and specifically when it comes to intelligence gathering, you cannot assume that in like huge battles, not like counterterrorism operations that are targeted, but like, you have two armies fighting over a city. Just imagine an international armed conflict, like heated battle, like World War II, whatever.
Ukraine-Russia.
You cannot imagine a case where a Ukrainian battalion says, I don't have sufficient intelligence, I will just not shoot any building in this city, right? So there's a certain amount of fire that needs to be produced in order to have an effective combat operation. And what you do is you minimize risks during the intelligence gathering to the minimum level that you can, and these are the targets that are being attacked while you maneuvering, right? Because maneuvering without supporting fire is something that no armies do, right? It doesn't happen. And I wonder to what extent this type of discussions are detached from the way of the actual conduct of hostilities in a way that might be academic in nature, right? So there is always an alternative. And in some cases, the alternative is not hold your fire, but you are you will attack some targets with less intelligence. And I think that it should shape, to some extent, this type of discussions about what exactly is the level of verification that takes place. And what type of, like, you can say that it's, like, I share the concern that that you express with your facial expressions, according to my facial
recognition problem
that I have.
Face print.
And it's like 100% accurate that you say, well, we know that there are like absolute prohibitions and we cannot just say something would happen. But there is, right, a nuanced version.
I just think this is a bit too abstract. Like so you know, you're approaching a city, and then the question is, do we just fire randomly at the city, or do we need to verify targets? We need to verify targets. You can't just randomly fire at the city. Yeah. So even though you like to fire things when you're moving, I mean, you cannot just randomly fire at the city.
Yeah, but what I'm saying is that we can have like two scenarios in mind, right? One is the one that we always write about. We target as part of targeting, right? So we have a specific target, a house. Then we think to ourselves, is it a legitimate military target? And it falls upon the issue of sufficient information that it's actually. There's another scenario where we have an active battle over a neighborhood. And we have two forces shooting at each other, right? And it's like capture the flag. You need to move from point A to point B. And in order to do it,
you do an artillery barrage.
You do, exactly. You protect your forces by time. So what are the targets? So there's no option of not having targets at all, right? So how do you choose the targets, right?
You don't.
You do not. Okay, so to some extent, so this is the right, so you should. But the alternative is whether, right? So to what extent you can verify that those houses.
I'll go one level. I think that we run to the scenarios that are easy to conceptualize. And it's always easier to conceptualize the activity of a small army unit. But much of the conduct occurs at the level of a battalion, a division, and so on, and things behave differently at those levels. And sometimes we miss the need to conceptualize how it happened at that level. When a division of tanks maneuvers, as part of the maneuver, it creates an artillery barrage because that's part of the protection. It doesn't do it in order to harm specific targets. It does so as part of the protection of the force when it maneuvers.
What are they firing at? Like, if you're telling me they're just firing randomly, I don't see how that's legal.
The aim of the firing is to camouflage their exact position.
But then you can do that by smoke, whatever thingies, right?
Smoke thingies.
I know. I don't know about the official, the Jonathan, whatever, John thing. I mean, I don't know. Like, but you're not allowed just to fire at civilian buildings because you want smoke.
The smoke thing is what you are describing, create fire. So they still burn something.
But are they firing at a field? I mean, they have to be firing at something. You see what I mean?
You are under. Like how do you picture it? Okay, so
I don't picture it at all.
No, like imagine the battle on Stalingrad. Okay, so let's go to like big battle with lots of forces, lots of fire. So there's a unit who's exposed to enemy fire, and they won, but the fire comes from undisclosed location, right? So they do not necessarily know if it's from window A or window B or from house A or house B. They are under fire. They want to go to capture the next street or whatever in the city. What are they supposed to do if they don't know?
The line of barrage is in front of the
alternative?
tank. It is moving with the maneuvering unit. You are creating a line of fire that is in front of you, that is aimed to protect your force from the force on the other side. So what determines the target is not what is there, but its location in relative to your position. It's a target due to its
So the military objective is an object that by its nature, purpose, location, or use.
Its location relative to the maneuvering force.
Fine with me. I don't have an opinion on this.
Okay, now how do we connect it back to London?
I don't know. I have no idea.
I don't know how we got here.
You did.
I did, but never mind.
You also in the line of barrage.
Yes, I think we need to move for the next topic, otherwise it's going to be a basic IHL discussion, which we all love to do anytime, but I think right now we are in non-technology realm.
So pivoting back to technology, I think you mentioned AI, so I'll develop a little bit on that. It's AI is like one of the emerging and disruptive technologies besides quantum photography, connected vehicles, it's technology in general. But I think with regard to AI, there's the most regulation by the acts coming out. So AI subvention. So we're within the EU AI Act, also with regard to other emerging technologies, Resilience Act, today's Cybersecurity Act, certifications. The little problem with all what I've mentioned is the laws excluding their applicability to national security interests. But perhaps as a general question, would this be a way of advancing national law, trying to all-encompassing convention on how states should behave in cyberspace, what they should or shouldn't do? Would it be certain alternative to regulate the defense, specific technologies that are vital to cyberspace, such as AI? So in the AI convention, there's 10 articles, principles that should apply. Usual principles from human rights treaties. But then there's a specific article on approach, risk and impact management. So it's more technical. So do you think this would be a way to advance international law, protecting cyberspace in general?
I'm not familiar with the AI treaty at all, but I think that one of the biggest problems with trying to regulate AI, autonomous systems, etc., is ironically the binary approach to this world, where we're going to regulate everything, and everything is going to be regulated within one set of specific rules that one fits all, or it's non-regulatable. Regulatable? Yeah, good enough. And then the diversity of technology and systems and abilities and impact is huge, that it's impossible to address it as one solution fits all, and we need to break it down to separate issues, different issues, and address them as such. And if you compare it, well, I'll just undermine myself, but if you compare it to IHL, we have the big principles, but then when we need, we have conventions on chemical weapons. We have conventions on different types and different restrictions that are more focused to specific issues rather than try to regulate everything to that level of resolution that would fit. So we have the basic principles. I think would work on technology. Again, I'm not familiar with the relevant treaties, but if it goes on basic principles and then separately we address specific issues, that would be more beneficial than to try to have one treaty or one set of rules that will cover everything. So if you can get international agreement on specific things, you can definitely have some development in international law that would use IHRL, that would use the IHL, and then apply it to advanced technologies.
Yeah, I agree with that. I think we have, regarding digital technology, we have this tendency to think, okay, it's a new technology, we need to look at this technology. Instead, it would be better to say, okay, this technology in this field changes that. So just an anecdote, I was working on the Swiss data protection law. And Switzerland is not very advanced in digital regulation. So it's basically data protection law is the digital law. So insurances wanted us to get in there stuff on how banks can work with digital means that kind of interferes with their interests as insurances. I thought that's not data protection. It's banking or insurance law. And I think the same issue applies to many of these technical questions. Instead of maybe the AI Act is like, it's good, it's like a general principle thing. But otherwise, we need to think these questions not in the context of technology, but in the context of their fields. And then it's also not a new whatever thing, but a new article in a convention that already exists. They're probably still hard to negotiate. I'm not familiar with that, but it's probably easier to have a new article or protocol or something than a new convention.
So is there, well, like, okay, there's a general clause on the weapons review mechanism, right? In IHL.
Maybe it's that someone ringing.
Someone is calling.
Someone is trying to, maybe the interphone or something.
Yes.
No, they just need to be admitted into the call, or no?
No, this is not part of the.
It's not.
No, it's not the computer.
It's not you.
We are talking.
No,
talking.
The Minerva people are calling somebody.
No.
Yeah, Minerva Haifa is talking.
Yes, this is the
this is
this is
Minerva.
us.
Oh, I see.
You are part of Minerva.
I'm Minerva Haifa.
You are Minerva.
I am Minerva.
But Amra is downstairs with.
But she has the key.
She has the key.
But wait, it stopped. Are we fine?
And Susie, she left.
Susie had to leave. Susie.
Susie.
Okay. Sorry, someone was in the middle of a sentence.
Oh yes. Could there be some parallel with the system that is set up in IHL, weapons review mechanism, or say means and methods of warfare in general when it comes to specific technologies?
I wouldn't jump to IHL because IHL is the regulation of chaos in a way. So you don't. I think trying to get into more organized frameworks rather than those who are trying to regulate how people kill each other, then I would try to find nicer frameworks.
By the way, that is also today so difficult, so dangerous. Are you guys all familiar with the new UN Cybercrime Convention? No?
In Germany.
So it was negotiated. So it started off as a Russian proposal, right?
That always starts.
And they succeeded. So they succeeded to push it through, and they are happy. Western states say, but we also succeeded in many different ways in reshaping it. So they say they're happy. The people who are really not happy are all the human rights people. Because what does the treaty do? So it basically requires states to punish certain cyber-specific offenses, you know. Well, the act is hacking computer systems, disseminating child sexual imagery. But then it creates all sorts of cooperation mechanisms for exchanging evidence and that type of stuff, which applies to serious crimes, yeah, which can include stuff that is not of cyber nature. And so it can be used to facilitate cooperation between authoritarian states and hybrid regimes, you know, about political offenses. There is one human rights clause in that treaty, yeah, that sort of courts, domestic courts are meant to apply as a safeguard. But like the question is, will they? Yeah, it depends on how they're trained. And then there's a provision in the treaty for a new protocol, which will be negotiated from 2026, about adding extra crimes in. So like, if you want to negotiate a new treaty today with Trump, like, you know, you need to be careful about what you're bargaining for, right? Sometimes it's better to rest on older principles and say they apply to new issues than it is to negotiate a new treaty. I mean, sometimes it's the other thing is true, right? But you need to be careful in what you want.
Well, this is the paper about how the ILC moved from draft treaties to they have like general studies from the fear that people treaty will actually weaken the situation, while having this type of study can be considered at some point in customary.
Also true, but I mean, new treaties are being negotiated. So the new, so again, a few weeks ago, the Sixth Committee voted, the General Assembly voted to start formal negotiations on a new treaty on crimes against humanity. But like the timeline they're giving is 2029. Yeah. So I mean, again, it is not a terribly wonderful atmosphere for concluding multilateral treaties. I mean, one needs to be careful. That's all.
2029 was not that far away.
5 years to negotiate a text that already exists. Yeah, so they already have an ILC text.
Come to the UN.
Yes, so unless there are like other technologies that we might discuss in detail, we might move on to the question of attribution, accountability. So our current mechanisms, are they enough for states to use like facing cyber operations?
I think I missed things. We had our own workshop at our university, so we were organizing that.
Right on time to answer all of the questions. We have a list of questions. We're going to solve them.
So, is there any way of being able to improve the process of attribution internationally in order to be able to attribute certain operations? So backwards, or would that be? I would probably also be dangerous to try to put in a treaty. But do you see like any gradual developments in this particular regard? Attribution.
Are we talking about attribution to state actions or attribution to even non-state actors as well?
Well, primarily state actors because of articles of responsibility, but even there, regard to Article 8, if there's state practice or if there is on that, there are even developments you are aware of.
I really know that like from lectures that have moved away to more of the like it doesn't have to be a willing reach. Don't look at me, I'm not
willing to breach?
Yeah, you know, like
intentional.
Yeah,
intentional.
Thank you. Yeah. It doesn't.
Yeah. All the neglection of things can bring us to the ultimate. Sorry.
Yeah. Like for practical knowledge. Yeah. Attribution is a way of draft articles of dealing with the subjective part of the internationally wrong flags. So I think they tried to sidestep the notion of fault or will. That's the right translation. So they created slightly different rules in regard to attribution. And I was just wondering if you have any comments on state practice or opinion yours with regard to attribution. I think more and more states are coming up with attribution, public attribution. The Czech Republic, the public attribution with Germany, 8 years. Attributing a particular operation to Russia. I think the statement said that this particular operation is attributable to Russia. The question of whether it breached international law, that's like a different one. We did not go as far as saying that this was a breach of international law, but it was definitely something that Germany and the Czech Republic didn't like Russians. The Russians did. So, yeah, there are several cases of states attributing operations to other states. And I'm just wondering if it helps develop the rules.
I'm not sure there's an issue with the rule, right? So one question is the standard of attribution, whatever that standard is it problematic in some way, or do we need new ones? My own sense is that we don't need new ones. You know, most cyber operations are either conducted by people who are state organs, they work for the military, they work for an intelligence agency, or they are maybe done by a private group which is under the state's instructions or directions or control. The question is evidence you need and for what purpose to support that. And that question of evidence, what kind of evidence you need, I think the core point is sort of you don't need evidence beyond a reasonable doubt at all. And the question is for what purpose are you doing it? Are you doing it in the courtroom of public opinion? Or are you doing it in some other forum? Now increasingly you have even prosecutorial and judicial authorities essentially making attribution claims. So a couple of months ago, the United States filed an indictment against, let's say, 4 Russians who work for the intelligence agency. They work for GRU. They are state employees. They're organs. It's not like an Article 8 question. They're organs.
They were on vacation.
And the accusation is that they committed cyber attacks against Ukrainian infrastructure and against an unnamed Central European country. I'm not sure whether it's Czechia. And the question is, how do the Americans have jurisdiction? Well, the same Russians probed some government computers in Minerva. I mean, that's like a bit of a problem. But like, I mean, the attribution claim there is state organs did it. They have lots of evidence. They have evidence so that a grand jury on probable cause approved the indictment. In England, we've had courts decide attribution issues in completely bizarre circumstances when it comes to cyber. We had a family law case between the Emir of Dubai and his wife, Princess Haya, who escaped to the UK, fleeing her idiot abusive husband. And what he did is that he used Pegasus to hack her and all of her lawyers. And you have the family court of England and Wales establishing through balance of probabilities, whatever the standard they use, that the state of the United Arab Emirates did that. Yeah? We have immunity cases where there are cases against Bahrain and Saudi Arabia filed by human rights dissidents who are now in the UK, who got hacked using Pegasus or whatever, right? And essentially the question is, can you sue them in tort for causing personal injury? Can you sue these states in tort? And the High Court and the Court of Appeal have basically ruled on the basis of this territorial tort exception to immunity, stating that you can sue these states. And these courts have essentially decided that Bahrain and Qatar did do this. You see what I mean? So like, I think we sometimes do this whole phantom thing. Like we build up this whole attribution to something so difficult that it can't be done. It can't be done. Versus where, what, for what purpose? So if the family court of England can do it, I mean, the rest of us can do it.
The question is, can the ICJ at some point?
You could. It depends on what you give them.
Okay.
So I want to say something.
Hi everyone. Can you hear me well?
Yep.
Yeah.
Okay. So two points on the attribution question. One of them, even if we don't think about a change in the legal standards, we see in some of the recent national positions that states are at least specifying what they understand under different grounds for attribution. For example, when it comes to Article 8 of the Articles on State Responsibility, Instruction, Directions, Control, the German position is actually quite interesting and is saying that there need not be detailed knowledge of the technical aspects of a specific cyber operation. We see at least some development in the sense of specification in these national positions. And the second point is about who is doing some of these analyses. And something that I found quite interesting is that in insurance contracts, there's some discussed exclusion clauses that relate to nation-state cyber attacks. There was a big discussion at Lloyd's as to whether such exclusions should be put in. And then the question arises, are they talking about act of state in the sense in which we understand attribution in international law? Or is this something defined for the purposes of a specific insurance contract? But it might be that they're actually referring to international law standards. And then the question is going to be, who is going to make that assessment? On the basis of what criteria? And is that going to reach courts at some point if there is a dispute over whether a specific incident falls within that exclusion clause? That was not a conversation starter, I see.
We tried several things along the way, and we all failed, so don't feel.
If you want a recent case in Article 8, it's a non-cyber case. It's the Carter versus Russia case about the killing of Litvinenko, where the court attributes the conduct of two assassins to Russia. So it says Russia did it. And they expressly rely on Article 8 and they conduct a robust evidentiary analysis to prove it.
But generally speaking, attribution in the physical world is easier to obtain than in cyber world where it's easier to hide.
Sure.
Which makes it much more complicated.
But it's a question of evidence. It's not a question of we need different standards, it's a question of evidence.
Yeah, absolutely.
So that's why we need more and more cases of attribution so that we can look at what the states have.
Eventually, it will go down to evidence. And I mean, I would go, usually it won't be directly through the state, it will through some third actor, a private company, a different even a private person can an assassin is just a private person in that case. But to find and identify the chain of evidence to that person in the cyber world is, on the one hand, so much more complicated. On the other hand, you always leave
traces.
Yeah, there are always traces. It's more complicated, but it's possible. I'm not sure that more case law is what it will help, but maybe it will make it easier to connect. I mean, lower the threshold of evidence that you would need to get from A to B, but you would still need the evidence to get from A to B, and that will always remain a question of technology and not a question of the law. The only thing is that, you might need to violate some human rights in order to obtain that evidence, and that's a whole different question, right? It's not a question of the evidence of attribution, but rather how you get the evidence itself. And yeah, so eventually it's a question of evidence and how you obtain it.
I think this area is kind of specific because for combating advanced persistent threats, or state-sponsored groups, exactly how to call them, you need a long-term effort to collect their footprint, yeah, their modus operandi, and then you are able to attribute to them certain operations. So, yeah,
I think that's true. On the other hand, we shouldn't over-cyberize this. So the same attribution issue arises in all sorts of contexts that have nothing to do with cyber. So the European Court of Human Rights will have to decide, basically it's already decided, is the downing of the MH17 attributable to Russia or not? The court has to make that decision. Today, the Czech foreign minister, I just read in The Guardian, that 100 out of 500 suspicious incidents in Europe that range from cyber attacks to espionage to influence to sabotage are attributable to Russia. Yeah? So the DHL plane, what was it in Lithuania? Those kinds of, it's also an attribution problem. See what I mean? The question is, how do you prove it? And again, there's 5 people, they do their thing. The question is, what do you disclose publicly? Do you want to be believed? But that's a political assessment, right? How much do you want to put out there?
I mean, the only question is, do the evidence rules we have today, do they function properly in the context of a digital world? Mm-hmm. If it's not possible in this digital world to come up with the necessary evidence in a reasonable way, then we have to lower the threshold, whatever. I don't know if that is, but that would be the question. And maybe also we probably need to think about the state being able, like the state, if it investigates something, it needs to be able to have, to produce, to come up with it. So it needs to be technologically sufficiently advanced, which maybe, for instance, Switzerland isn't. So there is also maybe an obligation to be sufficiently sophisticated in the technical aspects, because it's not just like, it's not investigating by talking with people, but it's maybe sitting at a computer and looking at files.
Yeah.
And you need to be able to do that.
Have capacity.
Yeah.
But reducing the level of evidence is a dangerous thing.
Of course, it is. But if technology means that changes the field in a way that you will never be able to produce the necessary evidence for something, you need to adapt the law. Otherwise, it's not going to work anymore.
And then you get into risk of human rights.
Yeah. I didn't advocate anything. I just said that is the question.
So maybe we can pivot from that to the next topic, from collecting evidence to data privacy and encryption, and the request of the states to see inside to encrypted communication. So it's another round of these crypto wars that have been going on for the past maybe 40 years. For instance, the negotiations of the regulation on child sexual abuse material within the EU that has been going on for several years now. It really proves that there are differing opinions among states. This particular topic. So, do you think that end-to-end encryption is by itself protected by human rights law, being able to communicate in an encrypted way, or does it make sense to limit end-to-end encryption on a mass scale for national security purposes? Where would you draw the line?
Some WhatsApp and stuff like that, where it claims that one-to-one person communication is encrypted. Is that legitimate on its own? That is the question.
Yeah, it's about whether the state can mandate providers of communication and also communication platforms to be able to reveal the content of the communications to the authorities.
There's a new case.
Okay.
There's a new case called Podchasov versus Russia, which was decided this year by the European Court, where Russia had a law mandating that any kind of app that provides end-to-end encryption has to provide access to law enforcement personnel for various reasons. And the court said that's a violation of Article 8 and Article 10, that you can't have that blanket requirement because basically it destroys encryption for everyone. So it has now been dealt with by one human rights body, which is, and they were unanimous. And Russia will not appeal, obviously, because Russia is not a participant anymore. But the question is whether, like if the UK or France did that, now they have a judgment saying you can't do it. But if they try to do that and justify that by saying, we need to combat child pornography, how that would go. But the court has decided this now.
Yeah,
basically.
It's very good because, well, the Czech Republic as such does not have a position on this issue because we're not able to agree on it within our government. But of course, our agency, cybersecurity agency, is pro encryption. So we are trying to argue this particular direction, whereas the Ministry of Interior have a different opinion. And this fault line is also within the states.
But where do you stand on the US versus Apple situation, where it was in the context of counterterrorism operation, asking Apple to unlock the phone in order to get the data from the phone?
The main differences between this order being targeted to a specific crime, as opposed to pretty much undermining all end-to-end encryption on a particular territory. Yeah.
Yeah. What would then be the Czech government position versus Apple in a similar situation? The Czech government would ask Apple to unlock the phone?
But they can't.
It would ask them. It can force.
They can't. Like Apple can't do it.
That was the Apple claim. But since then, it has been 10 years since then, pretty much. So I don't know what is the current Apple ability towards the phone. That was the claim 10 years ago that said that they can't. I'm not sure this is still the situation. I don't know.
But that would mean that Apple subverted encryption on their phones, which they haven't done, as far as I understand.
In the end, they solved the situation by waiting for a while and hiring a security researcher who hacked the phone actually at some point. So Apple didn't have to do anything. It's just they achieved it by a side channel. So
they do it with certain software that is installed on the device, or is it a personal thing? So I don't know, they choose
I think they used the vulnerability that was on the phone that was not known at the time.
So they put a software that can read the messages that are going from phone to phone, like in.
No, they opened the phone.
They had
they opened the phone.
They had the phone.
So they had the phone.
They had the phone.
Okay.
Yeah, just couldn't do it.
So they didn't do it from far away.
No,
Okay.
not in this case.
Oh, okay.
Should always cut the fingers of the terrorists in the body.
It was in the movies.
Either this or facial recognition. Yeah. I think we're about to finish unless someone has another comment. We can conclude the discussion. Anything else to add, someone? Okay, so I suggest we move to the concluding part of the workshop, and I'm going to be brief enough to say that it has been a very interesting workshop, very informative, and the discussions were great. And for one thing, well, half of them, two-thirds of them are already gone, but I could not have done it without the amazing help of Jakub, and Anna. And
you're taking all the credit.
Yeah, yes. In the name of all organizers, thank you.
And as I said at the beginning, we are doing this. We had to do the workshop outside of Israel for the obvious circumstances, which are definitely not happy ones, and we want them to end. And we know of, as Yael mentioned in our presentation, we have over 100 hostages that need to return home, and we have several complicated, complex, or separate, integrated conflicts going on in our region that should really end soon. And if only for one reason is to have you all in Haifa next time, which is as good as any other to finish these conflicts and move on to what we consider normality. And apart from that, I am very happy that we had the chance to do it here in Prague. It's an amazing environment. It's an amazing view. And the only thing I wish I would have been better if those guys would finish building the roof. Sitting here for 3 days.
Do you want me to open the window so you can shout at them? I feel you have a real big need to do that.
For 3 days, and all they've done is that window.
But they've done it well.
Because our guy over there that was using the torch finished his work.
I don't know what's going on over there. Unfortunately. But
your stereo was more effective.
We are doing a lot of these conferences, different types of them, and some of them are longer. Sometimes we bring people for 10 days to Israel for this kind of workshops. Sometimes we do very short ones. But the one consistent outcome of that, of all of those workshops, is the building of a community. And we see that with returning players and friends who keep coming to our workshops, and then we always add more and new ones. And even in this workshop, we have friends who join us from the previous workshop in Salzburg. And we do hope to continue that tradition, practice, custom, whatever you want to call it. And we hope to keep in touch and hope to have you in our future events, whatever they're going to be into. And And as we are entering into a new project on cascading extreme conditions, if that topic is of interest for you, you're more than welcome to contact me and see if we can collaborate, because, well, we have budget for more workshops in that framework, and we do like
you can cut that from the video.
No, we are proud of the fact that we have budget and we want to use it in a good way to develop workshops and partnerships and collaborations. And well, budget is an important element of that. So I want to thank you all and have a nice day, and we'll see you at dinner.
Need like 5 minutes.